The money was there, every penny of it. $214,000. 31 years of night shifts. Holidays missed, birthdays worked. Evelyn knew exactly what she wanted done with it. She had told her children. She had told her sister. She had told her pastor. The only person she never told was the law. And the law doesn't listen to conversations. The law doesn't read intentions. The law reads documents. And Evelyn didn't have the one document that would have changed everything. If you are over 60 and you have money in a bank account, a retirement fund, a life insurance policy, or a home, I need you to stay with me until the end of this video. Because what happened to Evelyn is happening every single day across this country. And the most frightening part is that almost nobody sees it coming until it is already too late to stop. Before I tell you exactly what this document is and how you get it, I need to ask you something directly. Drop a comment right now and tell me where you are watching from and whether you or someone you love has ever gone through the process of settling an estate after a family member passed. Tell me what that experience was like, because I read every single comment, and what you share with me shapes exactly what I cover next. The people watching this channel are the reason this information gets out. You are not just a viewer. You are part of how this reaches the people who need it most. Now stay with me, because what comes next is the part that should have been taught in every school in America and never was. Let me take you back to before the end. Because to understand what happened to Evelyn, you need to understand how ordinary her life looked right up until the moment it didn't. Evelyn was 69 years old. She had retired after 31 years as a registered nurse at a hospital in Columbus, Ohio. She was not wealthy by any dramatic measure, but she had done everything right. She had saved consistently. She had a checking account, a savings account, a 401k she'd rolled into an IRA after retirement, and a small whole life insurance policy she'd taken out in her 50s. The total value of everything she owned, including the modest home she'd paid off 7 years earlier, came to somewhere around $340,000. She had 3 adult children, 2 daughters and a son. She wanted them to have it all. She had said so, out loud, on many occasions, at the kitchen table, at Christmas dinner, in phone calls she made when she couldn't sleep. Her wishes were clear to everyone who loved her. What she did not have was a will. Not because she was irresponsible, not because she didn't care, but because she had done what most people over 60 do. She had assumed it was something she would get around to. She had assumed her family knew what she wanted, and that knowing would be enough. She had assumed that the system, in the end, would honor what was obviously right. The system honored nothing of the sort. When Evelyn passed away unexpectedly from a cardiac event at 69, her estate went immediately into something called intestate probate. That is the legal process that kicks in when someone dies without a valid will. And intestate doesn't mean slow. It doesn't mean inconvenient. It means the state of Ohio, not Evelyn, not her children, not her pastor, not anyone who knew and loved her, decided what happened to everything she had built over a lifetime. That is not an exaggeration. That is the law. And the law has no memory of what Evelyn said at Christmas dinner. Now, here is the part that most people don't understand, and this is where I need you to pay close attention. Dying without a will is not the worst outcome in this system. The worst outcome is dying without a will and having assets that don't pass through a will at all. Let me explain that, because it is the piece that destroyed Evelyn's family's expectations entirely. When most people hear the word will, they think it covers everything they own. It does not. A will only controls what is called your probate estate, the assets that don't already have a named beneficiary attached to them. But many of the most significant financial assets people accumulate over a lifetime, retirement accounts, life insurance policies, certain bank accounts, Transfer automatically to whoever is listed as the designated beneficiary on the account itself. The will has no power over those assets. None. Here is where Evelyn's situation became a catastrophe. Her IRA, worth approximately $112,000, had a beneficiary designation on file. That designation had been filled out 22 years earlier when she first opened the account. The name on that form was her ex-husband, Gerald. They had divorced in 2009, but nobody told the IRA, because nobody thought to update the form. And the form is the law. Gerald, a man Evelyn had not spoken to in over a decade, received $112,000 from her retirement account within 90 days of her death. Her 3 children, the people she had spent 31 years working to protect, received nothing from that account. The life insurance policy, $60,000, had no beneficiary listed at all. She had let the designation lapse years earlier and never updated it. When there is no named beneficiary on a life insurance policy, the death benefit typically flows into the probate estate. And the probate estate, because Evelyn had no will, was distributed according to Ohio's intestate succession laws. Those laws have their own order of priority that doesn't ask about relationships, doesn't ask about need, and doesn't ask about what was said at Christmas dinner. And that's not all. The home, paid off, valued at around $110,000, was also subject to probate. Probate is not a quick process. In Ohio, it routinely takes between 12 and 18 months. During that time, the estate pays attorney fees, court filing fees, executor fees, and carrying costs on the property. By the time the legal process concluded, the home had been sold and the net proceeds after fees were significantly less than the appraised value. Her 3 children received some portion of what was left after everything ran through the legal machinery. But they did not receive what Evelyn intended. They did not receive what she had worked for. They received what the system decided after taking its share. And Gerald, the ex-husband, walked away with $112,000. I have been practicing estate law for over 2 decades. I have sat across from families in exactly this situation more times than I can count. And every single time, the story starts the same way. The person who passed away was not careless. They were not uninformed in life. They were simply operating under an assumption that the system has never justified, that their wishes, if clearly stated to the people they loved, would be honored after they were gone. That assumption is wrong, and a system profits from it being wrong. But it gets worse. Let me show you how common this is, because what happened to Evelyn is not an outlier. According to data from the American Bar Foundation, approximately 67% of American adults do not have a valid, up-to-date will. Among adults between the ages of 60 and 70, the demographic most likely to have significant assets, that number barely improves. Roughly 58% still die without one. And of those who do have a will, a substantial portion have beneficiary designations on retirement accounts and insurance policies that have not been updated in more than a decade, meaning the documents that actually control the largest assets in their estate point to the wrong person. The Consumer Financial Protection Bureau has documented cases in which outdated beneficiary designations resulted in assets worth tens of thousands of dollars transferring to ex-spouses, deceased relatives, or estranged family members. Assets that in every case the account holder would have redirected had they simply known that the will in their drawer had no power over them. One study, conducted by the National Association of Estate Planners, found that in estates where the primary account holder died without an updated beneficiary designation on at least one major account, the average unintended transfer, money that went somewhere other than the intended recipient, was $41,000. Not to a charity, not to a distant relative with a valid legal claim, to someone who the account holder would not have chosen had they been given the chance to choose. Think about what $41,000 means at 65 or 70. Think about what it means to a daughter who was supposed to use it to pay off her own mortgage. Think about what it means to a son who was supposed to use it to help his kids through college. That money does not disappear. It transfers to someone who had no part in earning it. Here's what almost nobody knows, and this is the reason this video exists. There is a common belief, I hear it constantly, that a will is the document that protects your family after you die. That if you have a will, you have done what you need to do. That the will is the finish line. It isn't. A will is one layer of a three-layer system, and most people who have a will have only completed one of the three layers. The other two, beneficiary designations and titling, are the ones that control the majority of the money, and they operate completely outside the will, completely outside probate, and completely outside the courtroom. Here is what those three layers are and why each one matters. The first layer is the will itself. A valid, signed, witnessed will is the foundation. It controls what happens to your probate assets, your personal property, bank accounts with no beneficiary designation, real estate that isn't held in a trust or with a right of survivorship. Without a will, those assets go to the state's default formula. In most states, that formula has no flexibility. It does not consider who needed the money most. It does not consider who you were closest to. It divides by the legal categories of relationship, in a fixed order, regardless of your actual life. Getting a will is not complicated. It is not expensive. A basic, legally valid will can be prepared by an estate attorney for somewhere between $300 and $800 in most states, depending on complexity. In some states, a properly executed holographic will, handwritten and signed, is legally valid without an attorney at all. The barrier is not money. The barrier is the belief that it can wait. It cannot wait, because you do not get to choose when you run out of time. The second layer is beneficiary designations. This is the layer Evelyn's family lost everything on. Every retirement account, your IRA, your 401k, your 403b, has a beneficiary designation form. Every life insurance policy has one. Many bank accounts offer what is called a payable on death designation or a transfer on death designation that allows the account to transfer automatically to a named individual upon your death without going through probate at all. These forms are not part of your will. They are separate documents maintained by the financial institution, and they override your will completely, every single time. What I would tell you if you were sitting across from me right now is this. Pull up every financial account you have, every retirement account, every insurance policy, every bank account. Look at the beneficiary designation on file. If you haven't reviewed it in more than 3 years, there is a meaningful chance it is wrong. Not wrong in spirit, wrong in law. An ex-spouse, a parent who has since passed, a sibling you've grown apart from, a blank field where a name should be. Any of those situations can redirect tens of thousands of dollars away from the people you intend to protect. This is not a process that requires an attorney. It is a form. You call the institution, ask for the beneficiary designation change form, fill it out with the correct names, and submit it. That is it. Most institutions allow you to do it online in under 15 minutes. The third layer is titling. How the assets themselves are held, whose name is on the deed, whether an account is held jointly, whether a property includes a right of survivorship, determines what probate can and cannot touch. Property held in joint tenancy with right of survivorship passes automatically to the surviving owner, bypassing probate entirely. Property titled solely in your name goes through probate. A home held in a revocable living trust also bypasses probate, and unlike a joint tenancy arrangement, it gives you precise control over exactly who receives it and under what conditions. The most common mistake people make when they first hear this is to run out and add a child's name to their deed or their bank account, without understanding the tax and legal consequences of doing that. Please don't do that. Adding someone to a deed as a joint owner can trigger a gift tax analysis, can expose the asset to that person's creditors, and can complicate the step-up in basis rules that would otherwise reduce their capital gains tax when they eventually sell the property. The right way to accomplish that goal, getting a home to a child without probate, is almost always through a transfer on death deed, where those states allow it, or through a properly structured, revocable living trust. The second most common mistake is assuming that doing this once is enough. Beneficiary designations and titling require maintenance. Life changes. Marriages happen. Divorces happen. Children are born. People you named as beneficiaries pass away before you do. If you updated your designations 15 years ago and your life has changed since then, and whose hasn't, there is a real possibility that the documents controlling your assets do not reflect the life you are actually living. Most people who follow these 3 steps and review all 3 layers honestly see meaningful results within 90 days. Not in a legal sense. There's no case to win, no refund to receive. But in terms of peace. In terms of knowing that what you built is going where you intend it to go. That is not a small thing at 65 or 70. That is the difference between a legacy and a lawsuit. The people who get this right are not the people with the most money or the best lawyers. They are the people who took one afternoon, not a week, not a year, one afternoon, to open the accounts, pull the forms, and update the names. That is the entire distance between what happened to Evelyn's family and what didn't have to happen. Before I close, I want to tell you what I know about Evelyn's family after everything concluded. Her oldest daughter, Patricia, was the one who called me. Not to hire me. It was too late for that. She called because she wanted to understand. She needed someone to explain how her mother, who had loved her children more than anything in the world, had left behind a situation that felt like a betrayal, even though she knew her mother had never intended that. What I explained to Patricia is what I've explained to you today. Her mother had a will in her mind. She had expressed it clearly to everyone she loved. What she didn't have was a will on paper, beneficiary designations that matched her intentions, or titling that protected her estate from the legal machinery that activates the moment someone dies. 3 layers. Her mother had 0 of them properly in place. The IRA money, the $112,000 that went to Gerald, was gone. There was no legal mechanism to recover it. The designation was valid. He was the named beneficiary. The law did not care that they had been divorced for 14 years. Patricia told me something I have thought about many times since. She said, "My mother thought she'd done the right thing because she'd told us. She thought telling us was the same as protecting us. Nobody ever told her it wasn't. Nobody ever told her." That sentence is the reason this channel exists. I need to ask you something before you close this video. Think about the person in your life, your spouse, your sibling, your oldest friend, who is over 60 and has never once sat down to look at their beneficiary designations. The person who has a will from 15 years ago that hasn't been touched since. The person who would be devastated to know that the money they've spent a lifetime saving could go to the wrong person or into the machinery of a probate court because of a form they never updated. That person may not find this video on their own, but you just did. Send it to them right now. Not next week, tonight. You could do more for that person's family in 30 seconds than any attorney they'll ever meet. In my next video, I'm going to walk you through exactly what happens to your Social Security survivor benefits when there is a gap in the estate planning documents, and the number of families who unknowingly forfeit benefits they were legally entitled to is something that will make everything I told you today feel like the beginning of a much longer conversation. Subscribe and turn on the notification bell right now. I cannot guarantee this channel will appear in your feed if you don't. And this is not a video you can afford to miss. If you're not subscribed yet, do it now. The next video may arrive on a day when someone you love needs it more than you realize. Before I go, Patricia called me again about 6 months after everything concluded. She had spent those months going through her own accounts, her own IRA, her own insurance policy, her own deed. She found 2 outdated beneficiary designations she hadn't looked at since her first marriage ended. She updated them. She called her brother and her sister and walked them through the same process. And then she said something I want to leave you with. She said, "My mother didn't fail us. The system failed her. But the system doesn't have to fail us too. Not now that we know how it works." That's the only difference between the family that loses everything and the family that doesn't. One afternoon, 3 layers, the right names on the right forms. You know how it works now. Don't wait for someone to tell you it's too late.